In November 2012, a 21-year-old in Mumbai posted on Facebook. She was questioning why the city was shutting down for a politician's funeral. Her friend liked the post. Both were arrested. The charge was sending a grossly offensive message through a computer resource. They were released within hours, but the arrests triggered a wave of challenges in the Supreme Court. 14 petitions in total, all heard together. And on the 24th of March, 2015, the court struck down Section 66A of the Information Technology Act entirely. Section 66A had come into force in 2009. Its language was borrowed almost word for word from a 1935 British law about telephone calls. The UK Post Office Amendment Act, written for a world of rotary dials and exchange operators, had used the phrase grossly offensive to describe certain telephone messages. India took that language, placed it in the Information Technology Act, and applied it to the Internet. The offense it created was sending, through a computer or communication device, any information that was grossly offensive or had a menacing character or caused annoyance, inconvenience, danger, obstruction, insult, or ill will. 3 years imprisonment was the maximum sentence. None of the words were defined. The offense was complete the moment a message was sent. There was no requirement that the message threaten public order. No requirement that it cause any actual harm. No requirement that it have any tendency toward disorder or violence. It applied to a message sent to one person. It applied regardless of whether anyone was disturbed. The offense was, in the court's words, complete just by sending a message for the purpose of causing annoyance, without in any manner impacting public order. The court set out the distinction that is now the constitutional standard for free speech in India. There are 3 kinds of speech: discussion, advocacy, and incitement. Discussion is fully protected under Article 19. Advocacy of even an unpopular cause is also fully protected. Only incitement, speech with a direct and proximate causal connection to public disorder or violence, falls within the restrictions that Article 19 permits. The court went through each of the 8 permissible grounds for restricting speech, one by one. Public order required a proximate connection that Section 66A entirely lacked. Defamation required injury to reputation, which the section ignored. Incitement required a tendency to produce public disorder, which the section had no element of. Decency or morality required obscenity, which was conspicuously absent from the section's language. Section 66. A fit none of them. The vagueness problem was equally fatal. The court pointed out that judicially trained minds, applying the expressions grossly offensive and menacing to the same set of facts, had reached diametrically opposite conclusions in English cases. If trained judges could not agree on what the words meant, there was no manageable standard by which a person could know when they had committed an offense. Vague laws trap the innocent by not providing fair warning. They delegate basic policy decisions to individual police officers and magistrates, creating precisely the kind of arbitrary and discriminatory enforcement that a constitution is meant to prevent. The government argued that the law would be administered reasonably. The court rejected this in terms that are worth keeping. Governments may come and governments may go. Section 66. A would have gone on forever. An assurance from one government does not bind the next. The constitutionality of a law has to be judged on what the law itself permits, not on the intentions of whoever happens to be in power when the challenge is heard. 2 things survive the judgment. The section dealing with website blocking was upheld, because unlike Section 66A, it had procedural safeguards built into it. The necessity had to be established. Reasons had to be recorded in writing. A committee reviewed the decision. A separate committee met every 2 months to check whether existing blocks were still justified, and the decision could be challenged in court. What Section 66A lacked was precisely this architecture of accountability. The provision dealing with intermediary liability, the exemption that platforms like search engines and social media companies rely on, was read down rather than struck down. The court held that a platform loses its exemption from liability only when it receives a court order asking it to remove specific content, not when any aggrieved person complains. Millions of requests are made to platforms daily. Expecting each intermediary to independently judge which ones are legitimate would make neutral hosting impossible. The court order requirement protects both speech and platforms. The judgment ended where it had to. The line between protected speech and regulable speech runs at incitement. Discussion that someone finds offensive is protected. Advocacy of a position that most people disagree with is protected. A post about a funeral shutdown that annoys a governing party is protected. The law that made otherwise innocent expression into a criminal offense, without any of the safeguards that constitute reasonable restriction, could not stand.